Hello, everybody. I'm Doreen, and today we're speaking with Frank Sisson III. Frank is an attorney who practices law in Connecticut, New York, Florida, and New Jersey. And after years of working as legal counsel with other prestigious firms, Frank opened his own practice, Sisson Law Offices, in Westport and Stamford, Connecticut. During his career, Frank has concentrated primarily in the areas of estate and trust and related tax planning. How are you today, Frank?
I am doing great, Doreen. Thank you very much. I hope you are the same.
Thank you. We are. And thank you so much for joining us. I know you're super busy and you're squeezing me in, and I really appreciate that.
Never a problem talking with you, Doreen, but it is very busy times for us estate planning attorneys, for sure.
Yeah. So I wanted to ask you about that, Frank. Like right now and during these last 6 months, hard to believe it's been 6 months already, 7
Sure.
almost. What are you experiencing to be your clients' most pressing concerns on the top of their minds?
Well, needless to say, we've had a lot of people updating their estate plans who we've seen in the past. This is on everyone's mind with all the horrible news about the virus, COVID-19 issues, and respirator issues, and just horrible stories. People have this on their minds, and they're thinking about their own families, their own situations. They don't want to burden their families. They want to make things easy. Nobody's expecting the worst, but it's just in the air. So as a result, a lot of people updating their estate plans with particular attention to the living will document, which has to do with life support systems and what your instructions might be if that hopefully very unlikely event were to come to pass. And just in general, estate planning, distribution plans, trusts, how to reduce probate complications and delays. That's bringing people back that we've seen before. But we also have a lot of new clients who really kind of put wills and estate planning out of their mind, as we all like to do most of the time. But it's something that you feel better and less stressed by doing it than by putting it off. So we have a lot of new clients calling and asking for simple or more complicated planning to get those documents into place. More recently, Doreen, we've seen an increase in people calling worried about the very likely change in exemption levels for estate taxes. If there is a change in administration, right now we've got a federal estate tax exemption of $11.58 million per person, which for most of my clients is a safe harbor that they're in. But if we have a change of administration, there is talk that may well go down to perhaps as low as $3.5 million per person, which is a lot of money for most people. But in Fairfield County, Connecticut, and this general area, it's not that hard when you start adding in life insurance and the value of a home in Fairfield County, even after a mortgage. It is a net figure, not a gross. But it is on people's minds as well with the headlines. So that's driving people in as well, because they know that this is their time to act and that it may be too late if they wait until 2021.
Okay. And you mean because after the new administration?
Yeah, because it's not possible to transfer assets out of your name once the exemption is in effect at a lower level. You can't take advantage of the high exemption we have now. But if you beat the clock, so to speak, get your assets transferred to your children or to a trust for family members ahead of the change of the exemption, that could be a very valuable step to have taken.
Okay. Can you help me, and I think probably a lot of people out there, understand a living will, from a high level?
Yeah, a living will, which I think is a terrible name for it because it has very little to do with living. And people are calling my office all the time asking for a living will when what they really mean is a last will and testament. So it's confusing to have that word will in both documents. A living will, though, is, we used to call it, when I first started my practice, a death with dignity form, or a final directives form.
I like that.
It has to do with decisions that you would not be in a position to make because when this becomes relevant, you're not capable of communicating. Basically, we're talking about a situation with a coma or a very serious illness where you've lost your capacity to communicate. And if the doctors have concluded that there is no chance of reversal, of course, that's relative, it's a human decision, but they're pretty careful, very careful. This directive, we call a living will, is a statement to the world, mainly the medical world, that you do not wish to be kept on life support systems indefinitely. The science has gotten so good. I actually had a client family in our office where one of the family members had some very difficult brain surgery, had never come out of that surgery consciously, and was in a coma for 7 years. She had not signed a living will. The family had to live with that situation for 7 years. She was biologically alive, but not really alive in a quality of life sense, but they couldn't do anything because she had not signed a living will. So it's a thing we don't like to think about too much or too often, but by not dealing with it, you may be creating massive problems in the future for your family in a hopefully unlikely event that it becomes an issue. So I don't know if that's enough of a explanation for you, but all states permit it. Connecticut has its own state-approved form. Some states don't have a state-approved form, such as New York, but Connecticut does. It's a very good form. The thing I like about the Connecticut form is it does permit you to name a family member. We call that person a healthcare representative. Doesn't technically have to be family, but usually is. And that person must consent to the doctor's decision to suspend life support systems. So I call it a lock with two keys, the doctors being one key, the family representative the other key. Both keys have to turn. So that's the living will. I think Connecticut has a very good approach. New York has a slightly different approach, but I do New York planning as well, and we use a form that's suitable for that state. And it's something you have in your file. You can always change it. You can always change the people you name to be your representatives. You can revoke it altogether if you decide you'd rather not have a living will in place. But it's something we all should at least consider.
Let me ask you something about what you said, because it piqued my interest. With sadly, this woman who didn't sign a living will. I would think with health insurance and everything the way it is these days, that the hospital wouldn't, or the insurance companies would no longer support, what it takes to keep a person who hasn't signed a living will alive.
Yeah, it's a good point. And I don't know what I don't think it's possible for the hospital to suspend treatment for financial reasons, for the same reason they can't turn people away from an emergency room. There's got to be some public support, some absorption of costs in cases where the family simply cannot pay. I believe that same standard applies to the hospitals. Now, whether the insurance companies cut them off at some point is another issue. You'd have to consult with other experts to explore that. But it's a good point. But in my practice, in my experience, I've not heard of a case where someone has been suspended on life support because of financial problems that have restricted availability of funds.
Okay, that's interesting. But I would imagine if you get cut off from an insurance point of view, that could bankrupt a family.
That's very, that's very good. And the family I'm talking about with the 7-year coma, they lost about half their assets once the insurance was capped out and the deductibles had been, used up and the coverage was used up. They went through about half their assets. At some point, the patient simply didn't wake up one morning. At some point, even the machines can't keep you going. So it's a point. And I've had a couple of clients actually have me write. You can alter the state form. They've had me write into the state form a clause indicating that if the financial strain to the family becomes an issue, if insurance stops covering, they want that to be taken into account in the family's decision to consent to the termination. So it's a relevant question, very relevant.
That makes good sense to me. I mean,
yeah.
that's just such a tragic situation to be in.